Welcome. My name is Jana Martin, and I'm CEO of the American Insurance Trust, known to most of you as the Trust. Thank you for joining us today for this informative webinar on Directors and Officers Insurance. This webinar is the result of the work of the Trust SPTA Advisory Council. Let me tell you a little bit about this wonderful group. The Trust has long been a strong supporter of state associations. We believe that by supporting you, we support our policyholders, and that our partnership allows for the most benefit for all of us. As many of you know, we instituted the Trust SPTA endorsement program many years ago, and we're proud to say that we're endorsed by 48 SPTAs. We're always considering new ways the Trust can be a useful resource for you and for your members. And in late 2018, we created the Trust SPTA Advisory Council. The focus of this council has been to brainstorm ways to enhance the mutually beneficial relationship of the Trust and SPTAs organizationally and financially. We've reached out to you through calls and surveys to identify what will be most helpful to you in your role, and this webinar is one of them. We have several other projects in development, including a webinar on marketing, the first presentation of which is on March 3rd at 1 p.m. Eastern Time, and a Leadership Development Academy project. Stay tuned for more information on these in the coming weeks. The current advisory council consists of the following SPTA executive directors: Dr. Ray Folan, Hawaii; Miss Amy Wilson, Mississippi; Miss Carmen Scar, Nebraska; Mr. Michael Ranney, Ohio; and Miss Martha Turner Quest, North Carolina. I'm privileged to meet monthly with these fine and fun members who represent small, medium, and large associations from various regions and who have a good mix of experience. We are open to hearing more ideas from you on ways we can continue to support you with valuable resources, so please reach out to us. Before we begin the presentation, I have a few housekeeping items to tell you about. First, if you happen to run into any issues, please contact our customer service center at 800-477-1200, 800-477-1200, or send an email to seminars@trustinsurance.com. If you'd like to submit a question, please click on the Q&A icon at the bottom of your screen. We'll have an open question and answer period at the end of the presentation, and we'll do our best to answer as many questions as possible. Also, a link to a PDF of this presentation was included in your registration reminder email. If you haven't been able to download this yet, we'll place a direct link in the chat box now. And finally, this webinar is being recorded so you can reference it later. Please contact your SPTA liaison, Karen Green, for access. The topic of D&O insurance coverage is one many of you have had questions about, and so this webinar was developed. I'd like to briefly introduce our speakers, Tim O'Shaughnessy and Sheila LeBeau. Tim O'Shaughnessy serves as Vice President, Chubb Financial Lines, and is based in White House Station, New Jersey. His primary responsibilities include oversight of financial lines underwriting for those accounts within the healthcare business segment. He drives the distribution and underwriting of Chubb's capabilities, including the development, underwriting strategies, account management, and the identification of opportunities to expand existing relationships. Prior to his current role, Tim has held various underwriting and management positions within Chubb. He has over 15 years of underwriting experience. He received his bachelor's degree in economics from St. Joseph's University. Sheila LeBeau is Director of Underwriting for Trust Risk Management Services, also known as TRMS, and has worked with trust insureds for 20 years. As director, Sheila oversees and enforces the binding authority granted by Chubb ACE Insurance Group for the professional liability program for the trust. She provides training and direction to the staff with the delegation of various underwriting levels of authority, but is the ultimate responsible party to ensure strict compliance with all referral criteria. Sheila's career spans many years of successful work in the professional liability and financial services space, which began after completion of her degree at the University of Wisconsin in Milwaukee. Sheila's expertise is in underwriting, and we appreciate her willingness to go the extra mile in supporting our policyholders. We're very fortunate to have both of you with us today, and I'm confident this will be a worthwhile presentation for our audience. Tim and Sheila, we're anxious to hear from you.
That might be the first time anyone's anxious to hear about D&O insurance, but Jenna, thank you very much for the introduction. As Jenna said, we're going to kind of guide you through today a high-level overview of what D&O insurance is. So the goal today is to briefly explain to you the purpose of a D&O policy, illustrate who the policy typically covers, examines how a typical policy defines claim and loss, highlight some common exclusions and why they may be on a policy, give some examples of the types of claims that we see, where they may come from, and to clear up some common misconceptions around D&O insurance. Before we begin, as this is an insurance presentation, we have to start with a legal disclaimer, meant only to clarify that the information provided here in this webinar is a product overview and not a coverage interpretation. As each of you have different policies with different terms and conditions, please see your actual policy to understand terms and conditions. If you can skip to the next slide. Thanks. So the question we get often is, what is the purpose of a D&O policy? The purpose of a D&O policy is twofold. It helps provide insurance protection for an individual's personal liability for those that may be directors and officers. And it also helps to provide balance sheet protection for an organization. The first part really allows individual Ds and Os to focus on their job. So before we really dive into a D&O policy and what that means, it's important for us to understand what the responsibilities of our D&Os, of what the responsibilities are of Ds and Os. There are two distinct responsibilities here. Directors of the organization set out the corporate policy, and officers carry out the policy. So what does that mean? Examples of some responsibilities of a director for a not-for-profit organization include setting and evaluating the purpose, the mission of an organization, as well as reviewing an organization's investments or endowments to make sure that they're performing well and that the allocation is appropriate for an organization's tolerance for risk. Officers, on the other hand, are agents of this organization and carry out those obligations. Officers and their responsibilities are typically set by statutes, as well as bylaws, articles of incorporation, and they carry out the day-to-day operations. Titles and duties of directors and officers are found in those articles, incorporations, and corporate bylaws. Positions included in officers typically include the chief executive officer, president, executive director, chief financial officer, secretary, or treasurer. The legal duties of a director are somewhat distinct from their actual function. I like to equate being a director with sitting in the exit row of an airplane. It gives you some extra comfort, but there's some added responsibility. These responsibilities of a director are typically codified in common law in the United States and not necessarily under a specific set of regulations. Directors and officers owe these fiduciary duties to their organization and their shareholders and stakeholders. So there are three main duties of a director. The first duty is the duty of loyalty. This precludes a director from engaging in personal conduct that would injure or take advantage of the corporation. In other words, directors must avoid conflicts of interest. They're required to act in the best interest of the organization at all times. The second duty is the duty of obedience. The duty of obedience is defined typically by the corporate bylaws or charter or mission. And the goal is to abide by these laws and regulations that the organization operates under. The third duty is the duty of diligence, or often referred to as the duty of care. This requires directors and officers to act in good faith and consistent with what a reasonably prudent person in a comparable position would do under a similar circumstance. Failure to exercise proper care is really essential component of almost any lawsuit under the D&O realm that alleges negligence. These directors and officers are protected by legal principles called the business judgment rule. The business judgment rule makes them immune from liability to the corporation for loss incurred in corporate transactions that are within the authority and power, so long as the transaction was made in good faith. In most cases, courts won't take up a case unless there's allegations that the director violated their duty of care to manage the corporation to the best of their ability. The business judgment rule specifies the court will not review business decisions of directors who perform their duties in good faith with the care that an ordinary prudent person in a like position would exercise under similar circumstances, and in a manner that directors reasonably believe to be in the best interest of the corporation. Now that's all fine and good. So there are some protections and there's some backstop as to what you can do and what you cannot do to serve as director. However, the business judgment rule doesn't prevent directors and officers and their companies and organizations from being sued. We continue to see increased volume in the amount of complaints, amended complaints, lawsuits against both individual directors and their organizations. These suits can drag on for years, be costly to defend, and add stress to an organization's operations and balance sheet. D&O insurance is there to help provide that insurance protection for an organization in the event of these events. Now that we've established the purpose of what a D&O policy is, how does it typically work? In its basic form, a D&O policy will usually cover claims made against an insured for a wrongful act subject to the terms and conditions of the policy. There are a few important things to remember before we get a little bit deeper into what this policy actually is. First is that these policies are typically claims-made policies. They cover claims made against directors and officers or the organization within the policy period, as opposed to some certain types of insurance, whether it's professional or general liability, that may be an occurrence policy that covers when the act occurred. A D&O policy will typically cover claims made during said policy period. These policies also cover directors and officers for acting within their scope and capacity as a director and officer of the organization or subsidiary. In the case of you individuals on the phone or on the webinar, some of you may have multiple capacities, that you may act in the capacity of a director and officer or act in the capacity of a practicing psychologist. In the event of a D&O policy, it would cover your capacity as a director and officer. The final thing to remember about a D&O policy is that these policies are typically not named peril policies and are all risk policies. So what does that mean? It's important to remember that with this type of policy, what is constituted as a wrongful act is very broadly defined. Philosophically, it tracks with the broad duties of the director and officer. Usually the definition includes any actual or alleged error, misstatement, act, omission, or breach of duty committed or allegedly committed by a director, officer, organization. Because of how broadly that's defined, exclusions become an important part of the policy as they carve back the broad nature of what's defined as a wrongful act. We'll get into exclusions a little bit later. But in the meantime, let's talk about who's typically covered under a D&O policy. Next slide, please.
I want to add one thing here, Tim. This is also when an organization carries a nonprofit D&O policy, it a lot of times is requested by outside directors or outside officers who say, yeah, I'll sit on your board as long as you carry D&O insurance. So I'm sure you guys have run into that. Just wanted to throw that.
Exactly. That's a great point, Sheila, in that, the personal asset protection piece of this can be used as a recruiting tool and an ability to retain qualified directors. Right? Some of these individuals may have a background of sitting on an organization of a privately held or maybe even a public corporation that has had a history of lawsuits. It may not be as common in the not-for-profit space, but as we'll get into a little bit today, these claims exist and they come often. So carrying a D&O policy is a great way to comfort your directors that there will be some coverage for them in the event of an issue. So who is covered under D&O policy? Originally, D&O policies have been around for over 100 years, right? The goal of this was to originally cover the D's and O's and the people making the business decision. In the early 90s, due to some securities and litigation reform, where individual organizations will be held liable for certain things, coverage expanded to cover both the organization and the individuals. In terms of an entity, the D&O policy will typically cover the parent organization, who is the named insured on the declarations, and its subsidiaries. As with any policy, though, it's important to pay attention to the details. The term subsidiary can often be used and interpreted in a broad manner, when actually it's specifically defined in the policy. So certain things to look at are, what does the definition of subsidiary say? It usually comes down to two things, either equity ownership or control. Is there a greater than 50% stake in this organization, or the ability to appoint more than 50% of the directors and officers? What often is covered or may not be covered may not be exactly what you think. So it's important to take a look at your policy and match it up with your organization structure. Things like affiliates that may not be directly controlled or owned. Things like for-profit subsidiaries under certain policies that may only cover not-for-profit subsidiaries. Things like affiliates that may not hit the definition. It's important to understand how your organization's operations and structure match up with these definitions to avoid potential gaps in coverage at the time of the claim. These things can be discussed and can be added via endorsement, but the base policy often may not cover that. It's an area that we see frequently within the scope of our not-for-profit, private, and healthcare world, and that a claim comes in and it's submitted, and it's, well, actually, no, it doesn't fit the definition, but this is something we've kind of always viewed as a subsidiary. While it may not be an issue to add during the time of underwriting, it's always prudent to do it before the claim comes in. And you can work with Sheila and the team at Chubb to make sure that we're addressing your organization's nuance specifically. The second piece of who's covered are individuals. Individuals often include executives, directors, officers, trustees, managers, general counsel, committee members, and equivalent positions. I know that naming conventions may be slightly different from organization to organization, so we tend to paint a broad brush and then add the equivalence piece of it to most D&O policies. Employees and natural persons who are acting on behalf of the organization often have extended coverage as well. Next slide, please. So how is a D&O policy actually structured? Typically, there are three insuring agreements under a D&O policy, referred to as Side A, Side B, and Side C. Side A is the personal indemnity coverage. This is covered for individual insureds when they're named individually in a lawsuit as a defendant. Coverage provides indemnification for these individuals when the organization cannot indemnify. This is the clause that provides true personal asset protection for the individuals. Typically, there is zero self-insured retention in this case. And when this applies is when either the company cannot legally or financially indemnify its individuals. This could occur during bankruptcy when they're financially unable to, during a derivative suit in a private company when the shareholders are bringing suit in the name of the company against the directors, or in a claim example where it's for some reason against public policy or against the law to actually indemnify the individuals. Several significant issues regarding indemnification do pop up in bankruptcy events when bankruptcy proceedings are filed. Upon filing, there are a lot of hurdles and restrictions upon what a corporation can actually do and the money coming out of their pockets. D's and O's have to jump through several hoops to get indemnified when an insurance policy is not in place, often filing proof of claims with the bankruptcy court that may or may not be granted. D&O policies are structured in a way that individuals, D's and O's, have the ability to typically access this policy and its proceedings outside of that proceeding. The second piece of a D&O policy is Side B, which is corporate reimbursement. This clause is also directed at the individuals, D's and O's, except in this case, the company is indemnifying the individual. Corporate retention will typically apply, and coverage assumes presumptive indemnification, i.e. the organization will indemnify its directors and officers to the fullest extent permitted by law. These indemnification provisions are typically found in corporate bylaws and include some sort of protection for an individual director and officer. Could also be included or addressed within some state laws, depending on where you're located. An organization may indemnify its executives where they've acted in good faith in a manner that reasonably believed to be not opposed to the best interest of the organization, or in a criminal action proceeding where they had no reasonable cause to believe the conduct was unlawful. What this portion of the policy does is basically reimburse the company for its indemnification obligation to directors and officers. And the third part of a D&O policy is the entity coverage. If a director and officer is sued or alleged wrongful act, and the organization is named in the action as well. Entity coverage, or Side C, provides the entity itself with the coverage in the event that it's named in the suit. As I said, this has been around since the early 1990s as a coverage enhancement typically aimed at private and not-for-profit organizations. Typically covers corporate liability for claims brought against the organization covered under this policy. What we've seen is the majority of claims include entity, with about somewhere between 50 to 60% of the claims that we see across our book also naming individuals. What Side C does is provides that balance sheet protection for the organization. Next slide, please.
I have a question, Tim. Under coverage A, B, and C, are they sharing a limit? Is there one blanket limit that covers all of it?
So the way that the policy is typically structured is there one blanket limit covering all of it. However, many D&O policies will have coverage extensions specifically aimed at individuals and directors and officers, so that if an organization's A, B, and C coverage may be, a limit up to $1 million, there may be a kind of sidecar or additional coverage clause for an additional $500,000 or $1 million dedicated to these corporate executives.
Okay.
So at the end of the day, that if there's an instance where the entity claim erodes the limit, there is still some level of protection granted to these and O's.
Okay. Thank you.
It exists. Work closely with Sheila and team to make sure that that type of extension is generally included under the coverage.
We do include it.
That's so. We talked about who's covered. We talked about how the policy is structured. Now, the other important part of the basic tenet of a D&O policy is what's a claim? The definition of claim typically includes written demands for monetary or non-monetary or injunctive relief. While most policy forms include a number of other civil, criminal, administrative type claims or investigations against individuals, this first definition covers pretty much anything. Someone either wants money, which is monetary relief, something other than money, which is non-monetary relief, such as enforcing a contract, or to stop you from actually doing something, which is injunctive relief. All of the claims typically fall in one of these three categories. So moving on to the definition of claim, to what's loss, right? The definition of loss typically falls into two different buckets: defense cost coverage and indemnity coverage. Indemnity meaning judgments, settlements, potentially civil fines and penalties imposed upon individuals, punitive damages or multiplied damages where they're insurable. What's not typically covered are things that aren't permissible to insure, such as taxes, criminal fines, cleanup costs, things of that nature, the cost to comply with injunctive relief. Indemnity will almost never be covered loss for claims that are excluded by the policy. However, defense costs could be treated a little bit different, so it is important to understand how a policy handles allocation between covered and uncovered loss. Typically, a policy is structured in one of two ways: a duty to defend policy, where it's the duty of the insurance company to defend. Often, there is potential for full coverage for defense costs for claims that may include covered counts as well as potentially uncovered counts. This comes into play oftentimes when the claim carries multiple allegations against multiple parties. Under a reimbursement policy, where it's the duty to the insured to defend and then therefore the reimbursed by the insurance company, there may be allocation on both defense and indemnity. And that becomes important as we further talk about exclusions. So if we skip ahead to the next slide. So every D&O insurance policy is going to carry some combination of exclusions. What we're going to get into now are some of the common exclusions that we see on a D&O policy and the thought process as to why they appear. Exclusions are an important part of this policy as it's not named peril, as it is an all-risk policy. Depending on how a policy is structured, exclusions will be written to either apply to all insuring clauses, i.e. claims against both the entity and individuals, or to apply solely to claims against the entity. And they'll typically fall into a few common buckets. The first bucket we refer to are those events that are not really unforeseen. This is something traditionally thought of the proverbial, burning building. These exclusions will typically apply to include a prior pending litigation that is already in process or claims that have already been noticed to another management liability policy. The second somewhat broader bucket is claims that would be covered elsewhere under different insurance coverage. This typically includes claims for professional services where an E&O policy may be available, claims for bodily injury or property damage or personal injury that may be covered under a property or general liability policy. The third bucket of claims are claims that would be considered either uninsurable or a moral hazard. These typically include conduct exclusions. Conduct exclusions are generally aimed at individuals and are typically claims that would kick out things that are deliberately fraudulent or the gaining of personal profit when which an individual wasn't entitled to gain that. These type of exclusions, while on a policy, typically don't kick in until claims are finally adjudicated against that individual. So throughout the process, the idea of innocent until proven guilty applies here. And then the fourth bucket, which is a little bit squishier and is a little bit more tailored from an individual risk or an individual risk type, are those claims for specifically identified perils. These exposures are something that a company or an underwriter feels that they're unable to underwrite to, or there's an inability to adequately charge or assess the risk. These could include claims for antitrust violations, claims by specific shareholders, specific entities, or arising out of specific events. Some of the questions that came in for this presentation kind of get me thinking about this one, and my favorite question was, can we cover anything for a price? These are the type of exclusions that may have the room to be negotiated for either additional premium or different or amended terms and conditions. So it's worth discussing with Sheila and team again around certain things to say, while it may not be covered today, is there a way to cover it? And those are conversations we have regularly. The answer may not always be yes, and it may be specific from risk to risk or industry to industry, but it's conversations we have to regularly assess these types of coverages. Now that we've kind of talked about how a policy is structured, where do these claims come from? So if you could skip to the next slide. The traditional D&O claim that you think about is a suit or a complaint brought by a company's shareholder against the company's directors or its officers. The claim alleges that the decisions made by the company had a negative financial impact on the value of their investment. These shareholder claims, while common and occurring every day, only make up a fraction of the claims we see across the book. Other areas that we see claims for and include, claims from donors or resulting out of a donation or a grant. These claims will typically allege that donations were not used in the manner that was stipulated when the donations or the grant were made. Allegations include financial mismanagement, breach of duty, and breach of contract, and can tend to be costly to costly to resolve. Claims that we often see come from members or customers. These claims could allege deceptive trade practices, dishonesty or fraud, breach of fiduciary duty, lack of transparency around financial reporting. An example of this type of claim can come from a member or customer, could be the lack of transparency around where funding is coming from. If an organization makes specific recommendations either for a product or a service, and those recommendations are being funneled to their largest donors, and an organization is not transparent about that, claims may arise that the lack of transparency and the lack of forthcomingness by the directors and officers had a negative impact on either a competitor's business or a negative disparaging impact to the members or the customers. We also see claims that come from vendors alleging breach of contract or breach of fiduciary duty for services that were never rendered or improperly rendered. While contractual costs are rarely covered or included in covered loss, the common trend that we see with these claims is that an individual will be named, and there may be a defense responsibility. These type of claims can last for a very long time and often be amended, which is where the importance of the defense obligation of a D&O policy comes into play. A fourth bucket that we commonly see are claims from the government. These types of claims come in two different packages. The first may be a direct claim from the government. Could allege anything from violations of consumer protection laws to violation of environmental laws to tax laws or financial issues with IRS reporting. The second bucket that we see is in the form of a qui tam lawsuit, where there's a whistleblower bringing suit on behalf of the government for misuse of funds. Something along the lines of a violation of False Claims Act that may be arising out of improperly billing the government for services that were promised. In each of the instances mentioned above, what's typically covered and not covered depends on the terms and conditions of the policy and the specifics of each claim, including who's being named, what allegations are made. What we've seen recently over the last 5 to 7 years is the trend is the plaintiff's bar is becoming a little bit more aggressive in who they name. So as I mentioned earlier, we see individuals along with the entity named in more than half of our claims, as well as amending complaints. So the original complaint may have 1 count, an amended complaint may have 3. An example that we have currently going is a claim that we've seen against a condo board. An individual who bought a penthouse and is very wealthy wanted to build a pool on the roof. And the condo board has repeatedly said no. And this individual has brought claims about how they elected members, his due process, and things like that, and has amended multiple times over multiple years to the tune of almost $1 million for this condos association's defense costs. So, while not necessarily apples to apples applicable for the audience on the phone, what we've seen is these types of complaints often come and can linger, and the defense costs keep running and running and running. And I know that this is a presentation focused on directors and officers liability, but it is briefly worth mentioning employment practices liability. This is the insurance that typically covers an organization and individuals against claims for harassment, discrimination, wrongful termination, and retaliation, amongst other things. For not-for-profit organizations, EPL claims are by far the most common claims we see. Policy will typically cover first-party claims, or those claims brought by employees of an organization. This policy extends to the board and those organizations without employees. So while there may be no employees, there may be harassment at the board level that this policy would respond to. But an often overlooked portion of the coverage is the extension for third-party liability. This typically covers a claim for harassment or discrimination brought by a natural person who is not an employee of the organization. Think customers, members, or vendors. This type of claim can stretch from anything from a catcall to a delivery person, or allegations that certain criteria or standards developed by an organization are discriminatory against certain groups. We've seen an uptick of organizations that either set standards, set credentials, organize tests, or create some barrier to entry to a either trade or facility be undersuits for failure to accommodate how they apply those standards, failure to accommodate individuals with disabilities, or that those standards are inherently discriminatory against a certain group. So while we typically think of an EPL policy as necessary for organizations that have employees because it covers wrongful termination or discrimination or harassment, those organizations that may be publicly facing without employees may have some liability that an EPL policy could respond to. So if we can skip to the next slide. I want to briefly address some common misconceptions that we hear often about D&O policies. Right, D&O insurance is only for publicly traded companies. What we've actually seen is that from a claims frequency perspective, private and not-for-profit companies face basically the same risks as a publicly traded company, but in fact, the claims come more often and they have fewer resources available to them as a public company, so D&O insurance becomes more important. In the case of a not-for-profit, there are no outside shareholders, so it can't be sued. As discussed in some of the claims examples, we've seen claims by members, employees, government, creditors, and third parties. I don't need D&O policy because I have a GL policy or an umbrella policy. While there may be a little bit of overlap between a BOP policy and a GL or an umbrella, it typically isn't going to cover the financial consequences alleged for wrongdoing, such as breach of fiduciary duty or the mismanagement of the organization's operation, failure to deliver on certain services or disclosures, or things that really trace back to the duties of a director and officer that we discussed at the beginning of the presentation. The most common one that we hear with not-for-profit organizations are that not-for-profits are protected under state immunity laws. Not-for-profit immunity takes care of this. This is really one of the biggest myths versus reality that we face when discussing this coverage with not-for-profit organizations. Most states, there are protections for tax-exempt organizations that serve without compensations from civil liability within their capacity of directors and officers of these organizations. But there are limitations to those statutes. Some of these limitations include it only applies to the directors and officers and not the organization. It applies only to liability for negligence, not liability for gross negligence, reckless or criminal misconduct, or knowing violation of criminal law. It applies only to state claims and not federal claims. And not-for-profit immunity doesn't stop individuals or organizations from being sued. We've seen an incredible increase across the continuum of our insureds in litigation over the last 5 to 7 years as society delves into more and more litigious and plaintiff-driven. So just quickly in closing, a few things that I would like to take away from this session. Individual directors and officers owe fiduciary duties to their organization, their shareholders, and their stakeholders. Their involvement at either the most senior level of the organization or the day-to-day operations of an organization can lead to their involvement and their being named in lawsuits. As society is increasingly litigious, we're seeing an increasing trend of claims coming from every direction, making multiple allegations, and defense and settlement costs can be very costly. On top of that, increased regulatory scrutiny from various government agencies, both on a federal and state level, an increase in the amount of potential investigations into the liability. So purchasing D&O insurance enables an organization to attract and retain their directors. It allows the directors and officers to remain focused on the needs of the organization without worrying about their personal liability. And it provides some semblance of balance sheet protection for an organization in the case that a wrongful act occurs and coverage is triggered. Sheila, do you have anything to add that I may have missed?
I think you've hit on the points I was, the one thing about criminal acts, can you kind of elaborate on that a little? Because there's some information that I was given that if an individual director is involved in a criminal action and he goes down for it and somebody comes after the whole board for that, the rest of the board's going to be protected, defended is.
Correct. Yeah, there's severability with the policy, right? And there's knowledge. So, the idea of white hats versus black hats comes into play here. So that if one bad apple is doing something that is either criminally or grossly negligent, other individuals, so long as they are detached from that, they have some semblance of defense throughout the process.
Okay. I can't think of anything else at the moment, but let's see what kind of questions we might have.
Yes, well, thank you, Tim and Sheila, for your presentation. And I'm going to now share, we have a few questions in the Q&A box, and certainly people can continue to send them in and we'll answer as many as we can in the time allotted. So the one question is, can you please clarify whether an executive director's actions are covered under a D&O policy, subject to exclusions, of course?
Yeah. In their capacity as an executive director, a definition of insured person will oftentimes implicitly name executive director. And the actions of an executive director in their course of setting either bylaws or mission, and as well as executing on that, is covered, subject to the terms and conditions of the policy.
And what if an executive director is a third-party contractor that they've hired to come in and run the organization? Do they have the same protection? Because technically,
typically they would.
Considered the executive director.
Yeah, typically they would. Right. Independent contractors, depending on how a policy is structured, may leave room for interpretation, but the intent of a policy is often to cover that. So while it may need a little bit of tweaking to a definition of a policy, the idea that a contracted executive director is still the executive director applies here.
Okay.
Yeah, that's also relevant to a question that just came in. I think you've answered it, but there's a little piece. It says, if the executive director of the nonprofit is a contracted association management owner or employee, or simply a contracted executive director, do they need to be specifically and individually named in the D&O policy?
I would say no, but let's hear Tim's explanation.
Yeah, I don't necessarily think so, but every policy may be structured a little bit differently. So, is there a case where a definition may need to be amended? Maybe, but that's not oftentimes the case.
Right. Yeah. I think what this underscores is it's important to read your policy because policies differ. And it's important, and they're difficult to read sometimes and understand them. And so having some assistance or asking for assistance of what something means or what might need to be added is critically important. It's a big responsibility. So.
Yeah, and that type of question, not specifically that question, but that type of question, right, with regards to where intent intersects with contract language is something we get a lot. And it's something that we consistently try to work through to clarify with our broking partners, right? To say that the specifics of this risk don't fit cleanly into a definition. Do we have to go forward and change it, right? Because the intent, as I stated, is, this is directors and officers liability coverage, right? And an executive director, if defined by corporate bylaws or articles of incorporation, right? The idea is that they should be covered under the umbrella of this, and that's the intent of an organization when buying it. So we can work with our trading partners to craft situations or craft language to, make sure that the intent of the policy matches with the language. Mm-hmm. What you want to avoid in certain things like this is, and this kind of also goes in line with a blanket list of things like subsidiaries or affiliates, right, is that organizations change, people come and go. So it's imperative to make sure that you're addressing it in a manner that accounts for that. Something along the lines of executive director also includes executive director by independent employee agreement, something like that, as opposed to executive director also includes Tim O'Shaughnessy, who may resign 3 days after the policy incepts.
Right.
So structuring a policy in a way that gets to the root of the individual risk, because again, these policies are written in a way that may not be one size fits all. So for us to work closely with our trading partners and our broking partners and our clients to understand how the specific operations of an organization or the org chart of an organization intersects with the definitions of in terms of conditions of a policy are something that we can amend, and we do regularly.
Right.
Because again, it's much more pleasant to do that before a claim comes in than after the claim comes in.
Absolutely.
Right. I think that's a really good point that you raised, because I think a lot of us think that when we're given a policy to review, to consider purchasing, we assume it has to be exactly that way. And I think that the idea that you can ask questions and maybe have the policy tailored to things that might be unique to your association or your work or the work of your DNOs is really valuable information. So it kind of goes with another point that somebody else asked about was, does Chubb offer a consultation service for organizations that have DNO policies with Chubb through the trust and tier?
We typically don't from a DNO perspective. From an employment practices perspective, and the reason we don't for a DNO perspective is the types of claims we see are uniquely catered to organizations, right? That they are incredibly different and specifically tailored to a specific circumstance and time.
Mm-hmm.
On the employment practices side, we offer a little bit more on a consultative basis because those claims typically follow a familiar cadence or a familiar pattern from a litigation perspective and a claim perspective that policies and procedures or discussions with a third-party law firm can apply in a broader sense, where in a DNO claim perspective, they typically do not.
Mm-hmm.
Outside of, right, have bylaws and follow those bylaws and act prudently and don't commit crimes. Right, a DNO policy is so broad-based, and the claims that we see are frankly very different from claim to claim, that a consultative service is not the best use of time and energy here.
I think at one point in time we did in a meeting where Eric Harris was with us at CESPA meeting, I think it was in DC. They had offered that they would be able to consult sometimes, but it turns out that they usually end up referring them back to us because it's usually such a different situation that they're not going to give that kind of legal advice. They need that legal advice from an attorney.
That's
Yeah.
right. And their specialty is in risk management of practice of psychology, as
Right.
opposed to risk management of the policy itself. But Sheila, you often guide and provide support and serve sometimes as the person in between the insured association and Chubb, because you know about state psychological associations and you know a lot of the folks that are involved. And so there is that opportunity to call and talk with you. And if you feel like you want to run that by Chubb, someone like Tim or other, then that's an opportunity certainly for all policyholders.
Right.
Yeah. So here's another question. What is the type of claim small professional associations are most likely to see?
Yeah, that's an interesting question, and there's not really an off-the-cuff answer, right? Because the services provided by a small professional association range dramatically. Um, typically it's financial mismanagement is the most common claim that we see across all of D&O, right? It's some level of either lack of transparency or bad decision making that affected someone, right? Whether that's a member, whether that's a customer, whether that's a vendor. But there's no real, one size fits all claim. Again, if we were talking EPL, it'd be very easy, right? To say wrongful termination, retaliation, and discrimination are what we see. D&O are very, very different across the board, but typically it rises out of someone being harmed financially in some capacity or restricting their ability to operate their life or their business, and it's your fault, whether that's true or not, and why the idea that this policy is defense and indemnity. The defense is typically the lion's share of what we pay out across our D&O claims, because it's not cheap, and they may last a long time.
Right. So what about, can you provide us with a top 3 list of do's and don'ts for organizations like ours?
Not really. Follow your rules and don't break the law. Really, and again, it goes back to the duties of what a director and officer are, and kind of that business judgment role, right? Prudent decision making, involved decision making, and being engaged goes a long way. It may not stop lawsuits or allegations from coming, but it goes a long way in defending those
right.
lawsuits.
One of the
notes and things like that.
Say that again, Sheila. We talked at the same time.
I'm sorry. Meeting notes and things like that, often will help to explain what you were talking about and what the point was and why you, chose to go down that route. Mm-hmm. And that can come into play if there is a claim, and that can be used in your favor to help you get out of it. So,
right. Well, one of the things that we commonly tell our practitioner policy holders about decision making and what is prudent decision making, it is rarely, if ever, done in isolation if you're using a risk management approach. So, tying in with what you said earlier, Tim, an executive director who has a question about something, or a director that has a question, an officer, speak to someone about it. Get a consultation with a peer or someone within the association, so that you can hear yourself think through the process instead of just in isolation making a decision which you might not have thought about a certain aspect. So,
yeah, that's exactly right.
Yeah. Another question is, what policy limit do you recommend? Is it based on annual revenue or some other calculation?
Yeah, that's probably a better question for Sheila than myself. We see organizations ranging from tiny to multi-billion. And it's really what is your risk tolerance? What is your balance sheet able to support? And what is the preference of the individual directors and officers? So from my perspective, there's no right or wrong answer there. But Sheila, you could speak much better to that than I can.
Well, from my standpoint, we usually start at a $1 million limit. And it just seems like that $1 million will go a long way with some of these associations that don't have a lot of assets and don't have a lot to, protect themselves. So, but we've had other associations that had that may carry a $500,000 limit, and I don't think I've ever seen anybody interested or even asking about any limits greater than 1 million. So.
And so does the annual revenue come into play in making that decision, or the assets come into that decision-making process?
I think it's their risk tolerance.
Got it.
What do you think, Tim?
Yeah, it's risk tolerance and both revenue and assets, right? Because if you think about it, right, if an individual or an entity is sued, right, there's a cost to defending that, right? So from a balance sheet perspective, that money has to come from somewhere. And if you view directors and officers liability, as balance sheet, as a tool to protect the balance sheet, right, that, calculation of assets may be what drives your limit purchase. But if you think that you're large and operating in a certain function, it may be a function of revenue as well. There's no right or wrong answer to that question.
Yeah. So it sounds like you need to, as you said, what risk tolerance is looking at what do you have, what do you anticipate having, what are you willing, what are you able to support with those assets. Yeah. On a slide that you had, there's a question about what does with and without retention mean with regard to policy structure?
Yeah. So in the three insuring clauses of the policy, right, the first two, the first insuring clause is non-indemnifiable loss, right? So that is the loss when the company cannot indemnify the D's and O's. No retention would apply. No self-insured retention would apply there in most cases. There are certain states that require a low level of retention for some statutory reason. The B and C coverage, the indemnified loss that a company is able to indemnify the directors and officers, or the entity coverage, a retention typically will apply to those claims, a self-insured retention.
Usually just not for the individuals, just for the...
Right. Yeah, not for the non-indemnified individuals, correct.
Okay. I think we have time for one more question. Please review how and or if the entity is covered if there is fraudulent activity of a director or officer, parentheses, mismanagement of dollars, embezzlement, etc.
It all depends on who's bringing the claim and how the claim is brought, right? So if it's by members or if it's by a government organization that may have given funds or grants, right, the claim may look a little bit different. But if there's allegations of breach of fiduciary duty, breach of care, financial mismanagement against a company individual, and it's not subject to an exclusion, the policy would typically respond in defending that individual until there's final adjudication defending the entity.
Right.
But again, it's subject to the terms and conditions of the policy, right? That
read policy.
Yeah.
Right. So any last minute comments or guidance that you would give, Tim? And then Sheila, I'll ask you the same.
No, it's something that D&O insurance isn't something that is necessarily at the forefront of everyone's mind, right? It's their professional, it's their GL, it's their property. But D&O insurance is a valuable tool. And while every claim may not be covered, when the claim comes and it arises, both from access to defense counsel, access to an insurance company that has seen similar claims and has handled similar claims from a strategy perspective, it's a valuable tool.
Mm-hmm. Yes, we often say the worst time to think about wishing you had a policy is when you need it. So it's important to think ahead, again, from risk. Sheila, what about you? Any last closing words or comments?
I would be happy to go through any of the individual organizations' policies with them. I know that we address some affiliates in certain ways under some policies, but information, it was something negotiated. It's not automatic. So if you have affiliates that you believe or they believe they're covered by your policy, let's talk about it. Some states we list their names, so there's no question about them being covered. Same thing holds true for foundations and PACs. There is no automatic coverage unless you are completely responsible for appointing that board or their financial management or something along those lines. So we need to talk about those situations too. So please call me anytime.
Right. Well, thank you both very, very much. I appreciate your attention to the submitted questions that were previous and then the ones that came in today. And fortunately for our audience, we're not doing a quiz to see how much of that you retained. The other good point is that there is a fact sheet that we've made available to you. And this webinar will be available in recorded form in a few weeks on the website. So thank you everybody for attending and for your support. And thank you again, Tim and Sheila, for this presentation.
Thank you for the
Bye-bye,
opportunity.
everybody.
Yes, thank you very much.
Bye-bye.
Sure, bye-bye.